Hello and welcome to one and all. My name is Lakshay and I'm an intern at LEXCLIQ. I'm a third year law student as well in New Law College, Pune. And the topic for today is right to privacy of single mothers. Let's begin. Well, as we all are living in the 21st century and we know that this century is a great change in terms of technology and education, but also for breaking big stereotypes as well. It was also always looked down upon women who used to work, but not many women are. But now, not only many women are running their own companies, they are even millionaires, for that matter, billionaires. Another major stereotype which has been broken down is the one where women choose to be a single parent to their kid. Although this does not change the fact that there are certain hurdles posed by the Indian society regarding the furnishing the name and details of the father. The legality as to whether a single mother is eligible to give her name at all places to raise a child is the main question. The law which revolves around this is originally recognizing the male parent as the guardian for the child, and the mother does not have any right or independent legal status since all the government records demanded the name of the father. According to the laws of nature, women are considered as the natural guardians. The National Commission for Women, NCW, was of the view that the guardianship rights need to be reviewed and amended in order to do away with the age-long patriarchy. Thus, the NCW has recommended to the Union Ministry of Women and Child Development to modify the laws relating to guardianship, which can be implemented, would mean a clear win for every single mother in India. There are two major acts which are the Hindu Minority and Guardianship Act (HMGA) and the Guardianship and Ward Act (GWA), which governs the guardianship right of a mother, father, or a third party. Section 6 of the HMGA states that a father is the natural guardian of the child in case of a wedded couple, and it is after the father that the mother's right is recognized. But in case of a child born out of wedlock, it is the mother who becomes the natural guardian, and the father has no accountability or responsibility legally, as it is pretty evident that Section 6 of the HMGA is in clear conflict with Article 14 and 15 of the Indian Constitution, which guarantees equality rights. Therefore, it was called by the NCW to grant equal guardianship rights to both the parents, as that would pave a step for recognition of rights of single and abandoned mothers and rape survivors with children. It is also recommended to remove the term illegitimate from Section 6B, and taking into consideration the rights of the children that has no child should be considered illegitimate. As well as, we all can agree that a mother is the natural guardian of a child. Hence, the stigma regarding the unwed mother or a single mother should be completely discarded. To discard it, the first step shall be to amend the laws for better. There have been some steps taken towards it, like in the case of Geeta Hariharan v. Reserve Bank of India, AIR 1999 to SEC 228. The Supreme Court held that no preferential rights for either of the parents can be given, as the welfare of the child is the paramount importance. Section 6A of the Hindu Minority and Guardianship Act and Section 19B of the Guardianship and Wards Act and Section 19B of Guardianship and Wards Act, the phrase "and after him" should be read in absence of. This clearly means that the mother has the sole guardianship rights over the child if the father is not present, instead of getting the rights only after the death of the father. Although, after a very long and hard-fought battle, the Supreme Court decided to recognize the rights of privacy of single mothers and held that disclosing the name and details of the father of a single mother would amount to violation of her privacy. Though the Supreme Court found it better if the child would know the details of both mother and father, but the same knowledge will not be made available to everyone according to the court, and be available to the child in a sealed envelope which can be given to them on direction of the court if they deem it fit. The existing law will cause a very long and tedious process, and not everyone will be able to approach the court to claim their rights for various factors, thus calling the need to amend the existing laws. That was all for right to privacy of single mothers. I hope you understood and like this. Thank you.